Commonwealth v. Eli M. Velasquez Ortiz.
Good morning. Please proceed.
Mr. Chief Justice and Justices, may it please the Court, good morning. Martin Ritchie on behalf of Appellant Velasquez Ortiz. With me at council table is Jennifer Pucci. On September 28, 2006, Appellant pled guilty to two complaints then pending in the Brockton District Court, one from 2004, one from 2006. The 2004 complaint alleged principally possession of heroin with intent to distribute, possession of cocaine with intent to distribute, and a school zone offense. The 2006 complaint alleged a distribution of heroin on July 21st, 2006, a distribution of heroin on July 24th, 2006, companion school zone counts, possession of cocaine with intent to distribute, a conspiracy to violate the Controlled Substances Act, and then two assault dangerous weapon and a resisting arrest charge. With respect to those last three charges, the assault dangerous weapons and the resisting arrest, after the distribution on July 24th, the police moved in to arrest Appellant, who was in a car. Appellant tried to flee. He pulled forward and hit an unmarked police car in front of him. He backed up, hit an unmarked police car behind him. A third police car moved in and boxed him in. And it was a result of those circumstances, that sequence of events, from which the assault dangerous weapon resisting arrest charges sprang. In his tender of plea form, Appellant requested and the court imposed a 4-year sentence, 2 years in the House of Correction on the substantive drug charges, to be followed by the 2-year minimum mandatory sentence required by the school zone statute. He was also sentenced to 2 years in custody in the House of Correction on the assault dangerous weapon charges. The resisting arrest charge was placed on file. Annie Dukin participated in the testing of all of the drugs in both cases. And on that basis, Appellant moved for a new trial to vacate all of his pleas tendered on September 28th. The district court granted the motion with respect to the 2004 case, and that case is not before the court today.
And what would be the basis other than the fact that this was like a package and you're for saying that he would have any entitlement to withdraw the non-drug charges?
The basis, Your Honor, is that the Dukin misconduct affected Appellant's decision to plead not only to the drug charges, but also to the ancillary assault dangerous weapon and resisting arrest charge. Our appeal presents the issue how a court is to treat a motion for new trial where the case involved both tainted drug counts and non-drug charges.
So if you prevail here, then you go back, and I gather you have the presumption as to the drug counts, correct?
Yes, Your Honor.
But if the judge says, well, I think because they had him dead to rights on the ABDW and resisting arrest, and since he would have gotten time for those, I think he would have pled guilty in any event, even had he known of the Dukin situation, then you lose.
Well, if a judge were to conclude that, we would lose in front of the court, but I don't think that's the analysis that the court would do, because this is the argument that we would make. When Mr. Velasquez Ortiz was deciding whether to plead to the drug counts and to the non-drug counts, the drug offenses were the major driver of the case. They were certainly the major driver of the penalty and of the decision to plead. Now, in light of Dukin's misconduct, the question would be, would the defendant enter the same plea, or would he be insisted on going to trial? We suggest that He would insist on going to trial. The court would
Right, the court would consider all that, and you would argue that no, he would not have gone to, he would not have pled guilty because the major time was on the drug cases, and even if he'd been gone to trial and been convicted on the ABDW and resisting arrest, he wouldn't have gotten that much time, so he would have taken his chances and gone to trial. That's what you argue, and then she would argue something different.
He got no benefit essentially from.
But aren't you arguing though that it shouldn't go back at all?
That's right. We're arguing that it shouldn't go back at all. That on this record, it is palpable that he would not have pled guilty to the ancillary assault, dangerous weapon, resisting arrest charges, and that this court should find that the district court abused its discretion in denying the motion for new trial with respect to those counts.
But of course, the judge at the time didn't have the benefit of Scott, correct?
Well, Scott was not issued when the court made its decision, although with respect to the litigation of the motion for new trial, we argued under Ferrara. We argued under the Ferrara standard.
Wasn't it post-Scott that the judge changed his decision on the drug counts?
No, Your Honor, it was pre-Scott. The judge changed. The initial decision by the district court was to grant with respect to the 2004 case.
Right.
And denied with respect to the whole of the 2006 case. We filed a motion for reconsideration. Ms. Dukin was the confirmatory chemist in the 2006 case, so we emphasized that her confirmatory role was significant. Also, Kate Corbett was the primary chemist in the 2006 case, so the misconduct regarding her came to light. That was the basis for the motion for reconsideration. The judge then granted the motion with respect to the drug counts in the 2006 complaint, but that was before the Scott decision.
Okay.
So is it your view that when you have this kind of a grouping of cases, that as a matter of law, if the drug cases are vacated under, for instance, Scott, the entire case is unraveled?
No, our view is not that broad.
So the judge could have, applying a Scott analysis, a judge could have reached exactly the same conclusion that was arrived at here. The judge could have,
not on the facts of this case. I think in
Would have been an abuse of discretion in your view had the judge done that.
That's right, Your Honor. One can Scott.
but so in this case, the judge could not have said, "Yeah, I think he was going to plead guilty anyway. He didn't, based on the facts of the case, he didn't of the non-drug cases. That there's no way he could have won that case. He just, this was just a side issue."
We submit the judge could not have, within his discretion, decided that on the facts of this case. Whether an attempted battery or a threatened battery, the Commonwealth would have to prove intent with regard to the assault. Either that he intended to strike the police car, that he intended to put the police in fear. So intent is a real issue in this case. The appellant had a viable defense to these charges.
So if intent, part of my problem is if intent, I guess my problem is you would do all this as a matter of law. That you're resisting the idea that actually you do need a hearing on this. I understand why you are, because your client has been deported, correct?
Well, he was deported. He's since returned.
Oh, okay.
And
Faces federal charges in connection with that.
And there are federal charges in connection with that, and he's in custody with respect to that federal charge.
And that's why you want to undo the state charges.
Well, in connection with representing him in the federal charge, we saw that he had Plymouth County priors, drug priors, and we obtained the certs, saw that they were Dukin certs, and moved for a new trial in that context.
But you got rid of the drug case, the charges, but you didn't get rid of the other charges.
Well, that's correct.
Right.
And nobody forced you or forced your client to do this. There was no plea agreement in this case. The Commonwealth didn't dismiss charges in exchange for obtaining your client's plea.
Well, the Commonwealth did dismiss a conspiracy count.
In exchange as part of the plea agreement?
Well, that depends on how you characterize this tender of plea
He went in and said, I'll do this. Commonwealth says, we're not agreeing to that. And the judge says, well, I'm going to let him do it anyway. It's hardly an
In the
agreement.
entire plea, the Commonwealth agreed to the disposition recommended by the defendant on the 04 complaint. They had a disparate recommendation with regard to the 06 complaint, and they dismissed the conspiracy count on the 06 complaint. So there were disparate recommendations.
06 complaint is what we're talking about
Yes,
here.
there were disparate
The assault charges in the 06 complaint.
Yes. It was one plea, it was one proceeding, is why I mentioned the 04 case and the agreement there. But Justice Botsford, I want to be clear about your question as a matter of law. I'm not certainly not saying.
Well, I guess I'm looking at this through the lens of Scott, and in the Scott cases, issues got remanded for a hearing on whether the person would or wouldn't have pled, and knowing now what they know. And I guess I'm thinking your argument is, well, the record is such that he clearly would have pled, but nobody's actually adjudicated that, right? I mean, he would have pled, the record is such he wouldn't have pled to any of these charges.
That's my position.
I missed a negative in there. But you're saying that is clear on the record. It doesn't need to have any kind of hearing.
That is our position in the brief. If the court disagrees, then we would certainly ask for a remand so that we could argue to the court that he would not have pled guilty. And this is the A test that we would propose. In Scott, the court says that a consideration for a court in determining whether a defendant would have pled or gone to trial is whether the drug offenses were a minor part of a much larger plea. That suggests that if they were a minor part of the larger plea, then the misconduct didn't affect the decision to plead. That suggests that if the drug offenses were the major part of the plea and the non-drug offenses were a minor part, then the misconduct affected the decision to plead. And that is what would be argued to the district court if the court were to remand the case.
All right, thank you.
Thank you.
Good morning. If it please the court, Gail McKenna, Assistant District Attorney for the Commonwealth. I need to start, I believe, with addressing the court's belief that there's a presumption here as to the drug charges. There are not. And that's one of the problems here with the fact that the judge did not have the benefit of the court's guidance in Scott. Here we have an open question whether or not the defense counsel had the certs. That was put before the district court judge down there, and one of the problems here is that we don't have findings, and we have no idea what guided his decision here.
Do you need to have certificates? I mean, wasn't there some affidavit from the defendant saying that at the time I pled guilty, I was informed by my attorney that the tests came back positive for cocaine, heroin, and marijuana? There
were two sets of charges, and we don't know whether or not the judge credited what the defendant said.
You don't need the certs, right? You don't. The defense counsel didn't have to have the certs in order for there to be a Scott.
We don't know anything about whether the certs guided his decision. We don't know whether the certs had anything to do here. If he went ahead and pleaded guilty without ever having the certs.
But if he says he knew the test results, how? I'm not really understanding what the significance of the certs is, whether or not his defense attorney had the certificates or had been informed as to the test results.
First of all, you're assuming what the defendant says is true. We haven't heard from defense counsel here. And we know that at least as far as the withdrawing the assault and battery charge is concerned, the judge did not credit that because he denied that part of the motion, and that was the only basis upon which he could have allowed that motion. So we know implicitly that he discredited that. I would also maintain that that's not an affidavit because it's not a sworn statement, so that the judge would have had to, he would have had a hard time having to credit that. So the presentation in front of him was lacking.
No, I guess okay, but that's a slightly different question than what I'm asking. I mean, I thought that you were focused on the fact that there had to have been, the defense lawyer had to have had the certificates or had to have seen the certificates
We
as
don't have
opposed to being informed. If the defense attorney were to come in and testify, I didn't see the certificates, but I had been informed that the test results were all, there.
Oh, then I wouldn't be making this argument.
All right, okay.
Absolutely not.
Okay,
But there's no evidence here that defense counsel knew about the tests.
okay.
And the prosecutors, in what he explained to the judge, and he was very candid. He said, look, I'm not testifying here, but here's the practice. We asked for them on this particular date. They were picked up on September 18th. The plea happened September 28th. They weren't faxed over to the DA's office until October 3rd, and there's no cover letter to defense counsel. So, he wasn't clear exactly on whether or not defense counsel had them, and he was candid about that. We haven't heard from defense counsel. I know that my sister reached out to defense counsel, never heard back. In the absence of a hearing from defense counsel, the judge can conclude that there's nothing positive that defense counsel has to say for his former client. But, that's an inference that we let our trial judges make.
Counsel, may I ask you,
Certainly.
In my experience, I've never seen a defendant plead to part of the charges and not to all of them. I mean, does that practice, the way things really happen, should that be considered? Should that have been considered by the judge in this case? In other words, you've got 5 charges. You don't plead to 2 of them. The deal is you're going to plead to all of them, or you're not going to plead to any of them.
Well,
So why shouldn't that be a factor in considering?
you're talking about the conspiracy charge?
No, I'm talking about the judge allowing the withdrawal on the drug cases, but not on the non-drug cases.
The judge clearly didn't credit the defendant's statement that the drug charges drove the plea. That was the only thing in front of him was that statement, and he clearly didn't credit it because he denied that part of the motion.
I'm suggesting that might be an abuse of discretion because nobody pleads guilty to part of the charges and insists on going to trial on the other part of the charges.
I have seen that happen, Your Honor. I have seen that happen, where they want to take out one of the most potent charges and leave just for the trial a less potent charge to try and reduce prejudice against themselves. So I have seen that happen myself. Here, the judge made the determination that the crime of violence here itself stood as a very serious crime, I'm presuming, but he discredited what the defendant said. And that's something that, our rule of law says that we give deference and respect to. He's the guy on the ground making the decision and making the credibility decisions.
And what was the disposition in that case, the non-drug case?
Say again?
What was the disposition? It was filed?
2 years.
No, there were 3 charges. There were 2 ABDWs based on hitting the cars. They were 2 years each, concurrent. The prosecutor had asked for consecutive time, and there was a resisting arrest that was guilty filed.
Okay.
And the judge left those alone. But the thing that troubles me here, and I have to bring up to the court, is the relief that the defendant is asking for. In his reply brief, he asks that the court abrogate Scott as far as the drug cases are concerned and apply the normal Rule 30 rubric, and that he applied the egregious misconduct rubric to the assault and battery charges, and that's not something that the Commonwealth is supporting here. What we're saying is that the Scott case should apply here. The drug cases should be remanded for the appropriate findings because we don't know the legal and factual basis of what the judge's decision was, but that the assault and battery charges were properly considered by the judge under our normal Rule 30 standards, and that those should be, and that part of the case should be affirmed.
So if we remand, taking what Justice Hines has said, the judge could decide, no, I think that he would have pled guilty to all of them because the the non-drug cases were sufficiently important, he would have gotten enough time that he would have pled guilty to a package, and therefore he could be worse off than he is today if the case had been remanded. Or the court could say, no, I think the drug cases drove the plea, and therefore I order a new trial as to all the charges.
Well, you know, Your Honor, I think it's sufficient here, and we have to remember this is the defendant's burden. He came forward, he presented his statement to the judge, and the judge discredited it. I mean, that's black letter law here. The judge has discredited the statement that that's what drove the plea. And it's not an abuse of discretion because we're talking here about a crime of violence which is significantly different than the other charges. They're different in kind, different in type, different in impact on the kind of charge that it is.
But we don't have an opinion from the judge, do we?
We don't, Your Honor.
And we don't.
have
And this was all pre-Scott, so we don't know whether or not the judge applied the Scott analysis, do we?
But he's not required to apply the Scott analysis, I would
We
contend.
really don't know what his thinking was, do we?
Well, I think that as far as the rest of the charges are concerned, the normal Rule 30 presumption should apply, which is the defendant comes forward with the burden. There's no misconduct having anything to do with these assault and battery charges, and he made his statement, and his statement was that I wouldn't have pleaded guilty to these except for the drug charges, and the judge rejected the credibility of that. So that's been litigated, and there's nothing more there for the judge to consider.
And the judge
he
allowed the
disbelieved that.
motion as to the drug charges,
But we don't know why.
but we don't know why.
We don't know why, and he didn't have the Scott framework to analyze that for. I don't know if he.
But I'm having a little trouble sort of figuring out what your analysis here is. So you're saying he's allowed the motion as to the drug charges, so that stands, right? That doesn't stand.
No. I said as far as the drug charges are concerned, that under Scott, this stare decisis, this court's controlling law, it has to go back for findings because we don't know. We have no idea why he withdrew that, and the
But
defendant.
you're challenging the judge's decision to allow the drug charges to be withdrawn?
We have cross appeals here, Your Honor. Yes, I am.
Okay.
And I'm challenging in the sense that I want my Scott findings, and I want to know what the judge's thinking was, and I want the judge essentially.
But you're saying as part of that Scott analysis, the judge should not be able to take into account whether or not there would have been a plea at all.
Well, but
Anything.
But the issue here is he already did that piece, and he did that piece because he had the statement from the defendant that he discredited, and the statement was that this was a factor in the plea.
But wouldn't if we have a Scott hearing as to everything, including the drug charges, wouldn't the judge have to make a determination as to whether or not he would have pled to the drug charges?
Only on the drug charges, right? I mean, the only.
I know that.
I'm sorry, I didn't hear you, Judge Botsford. I mean, they're two separate sets of charges. Some are based on misconduct at the drug lab, which we don't know. Again,
But it was all part of the same plea.
Well,
It was a package, wasn't it?
yes. The defendant packaged it. It was a green sheet. It was his proffer to the judge. But the judge discredited that piece of it to the assault and battery was tied in or driven by the drug charges.
Did the Commonwealth oppose the plea?
I'm sorry?
Did the Commonwealth oppose the plea?
We had a disparate recommendation. We wanted more time, so it was not an agreed upon plea. So
But
this
there
is
was-
not.
was
There's
there
no
an
quid pro
agreement?
quo.
Was there an agreement as to what each side would request?
No, there's no quid pro quo here at all. It was a disparate recommendation. We wanted consecutive time. There was the 04 charges. We agreed on that. That's not before the court. The 06 charges, we wanted consecutive time. So, no, this was the defendant putting forth what he wanted, and he got it from the judge. This was not what we wanted.
You're saying the 04 charges are not before us, so that's not a subject of your cross appeal?
Correct. Correct. Those have been dismissed. And I will say, too, because I know the court inquired in a different case, that the drugs in this case have been destroyed. So, there's where we are with that too, but just for a matter of full disclosure.
The drugs in both cases, 04 and 06,
Well, of course, the case has been dismissed.
right,
That case is over.
and 06, they've been dismissed.
It's on the docket in 2010. And if there are no more questions, thank you all for your kind attention, and I'd otherwise rest on the papers. Thank you all.
SJC-11759, John DeRosa and others v. City of New Bedford.